Once again, continuing and finally concluding IDT 117 and the Washington Department of Corrections, the interest arbitration proceeding for the 1915-1917 collective bargaining agreement. Parties are present as previously, and all we have left today is closing arguments, which the parties have kindly agreed to do orally in light of the pressing contractual deadline for the issuance of the award lists. And we have agreed, they have agreed, that Dan is going to go first on behalf of the union.
Thank you, Mr. Arbitrator. So, right off the bat, it's important to remember why we just sat through 7 days of formal testimony and flipped through all those exhibit notebooks with the complicated D rings. We did that because the DOC employees are not allowed to strike. Otherwise, with a 98% rejection vote, we would have been picketing the prisons across the state. We would have been sitting outside around burn barrels instead of here around this conference table in Tukwila. That kind of overwhelming rejection, which is the highest voter turnout in DOC's history, is unmistakable evidence of widespread discontent with the state's last best and final offer. But the workers in the state prison system can't take that discontent out onto a picket line. So instead, they sent us to plead their case and convince you that they deserve better than the state's offer. The state's offer, 3%, that 3% increase doesn't even come close to what this group of workers deserves. Their actual current wages have been significantly reduced compared to what they once were at DOC. We know that they haven't had any raises at all since 2008. We know that there was a 3% wage reduction that lasted for 2 years. And we also know that the cost of living, as measured by the CPI increases, has decimated their inflation-adjusted wages over the past decade by 11 to 12%. The testimony of Will Aitchison on this issue is undisputed. The employer didn't even try. And you can find that analysis in Union Exhibit 20. That 11 to 12% is then compounded by the, again, undisputed impact of the increasing employee premium share during that same period, which is at Union Exhibit 22. So taken together, this represents a total loss of 13% since 2008. So the state's proposal for a 3% wage increase is essentially leaving this group of employees with nothing more than a 10% loss. That's probably why the proposal was so soundly rejected by the bargaining unit. It just doesn't come close to making up for the losses that they've incurred. 10% prison premium is justified. And Michelle Woodrow, the union's director of law enforcement and corrections, testified that the #1 priority for this bargaining unit is to increase what we've been referring to as the prison premium from 1.3% to 10%, and to eliminate the divisive GOP. Now that 1.3% has been eroded even further because it's recently been given also to members of the Federation who actually don't work inside the prisons. But working inside of a prison environment is significantly different than other jobs. We heard testimony from Dr. Suzanne Best, a whole host of statistical data that paints a very ugly picture of the mental and physical health impacts of working in a prison environment. Now, I'm not going to take a lot of time to go back over the details. It's all in her report, and it's in the presentation, which is in the record. But it's clear and uncontested that corrections workers endure an incredibly difficult and dangerous workplace where they live in a constant state of heightened vigilance. That takes a toll over the course of a career. It takes a toll over the course of a lifetime. We heard compelling testimony about these issues from rank and file witnesses. We heard from Michelle Alejo and Alicia St. John about how much more stressful and difficult it is to work in a prison, even when compared to doing that same job at another state institution like Western State Hospital. We heard incredibly compelling testimony from Sergeant Eric Smith about the traumatic working environment and the devastating impact that work can and does have on correction workers' personal lives. He lost his first wife because he couldn't talk about work with her, and he lost his second wife because she was also a corrections worker, and they couldn't get away from it. Eric's experiences are not unique. This work is unbelievably difficult and dangerous and and stressful, and it takes a toll on the people who do it. It's impossible to deny that fact, and I'm sure that's why the state didn't even try. The 1.3% doesn't even begin to compensate for that kind of toxic environment. It deserves recognition. Now, like combat and hazard pay, it doesn't fix the problem. It doesn't fix the underlying trauma and stressors of the job, but it goes a long way towards making workers feel appreciated. And it helps pay the bills, which certainly alleviates some stress. Now, we anticipate an argument from the employer that the union hasn't introduced any evidence of other jurisdictions where there's something like a prison premium. But that's because the money is already there. It's inherent in the comparability data itself. Those other jurisdictions are simply paid more for the same work. So let's take a closer look at the external comps. Now, we have several areas of disagreement about the external comps, and I want to talk about those. But at the outset, it's worth noting that no matter how you measure it, no matter what methodology you use, nearly all the positions in this bargaining unit are far behind the comps. The issue really is just how far behind are they? So these 5 issues, 5 areas where we disagree. First, we have a disagreement over which jurisdiction to use. Second, whether to compare top to top or top to mid. We have a disagreement, I'll slow down. So we have which jurisdiction to use, number 1. Number 2, whether to compare top to top or top to mid. Let me know when you're ready. So
Go ahead.
Okay. Third issue is total comp versus wages only. Fourth is how to handle cost of living. And then the last is what to do about the GeoPay. So turning naturally to number 1, which jurisdiction to use. The state's analysis that they're presenting is internally inconsistent. With respect to the job classifications that are statewide, in other words, not unique to the Department of Corrections, the state in its 2010 and 2014 total compensation surveys used not just other states, but also private and public sector employers in Washington, which, as Scott Frakes testified and acknowledged, are the real labor competitors with DOC. For example, we heard from Sean Van Eaton, who was a great previous DOC employee with 11 years of seniority, and he left a good bid position in a job he liked for the Monroe Police Department, where he makes more money as a police recruit trainee on injury status. We also heard from Ian Williams, also from Monroe, who joined many of his previous coworkers at the railroad, simply to make more money. That's where people actually go when they leave DOC. They don't go to work for Arizona, Colorado, Utah, Oregon corrections. They go to local employers. And the point, though, is that the different methodology leads to dramatically different results. When you include the in-state employers, especially county corrections, it shows a much deeper deficiency. This can be seen by comparing Union Exhibit 54, which is the end of analysis for the non-DOC specific classifications. And if you compare that to Union Exhibit 71, which is the end of the analysis for the DOC classifications, there are some classifications that you find in common on both lists. For example, if you look at the electronics technician, which shows up on both lists, under the state's 2014 survey, which included the in-state comps, the electronic technician was 13 ranges, which is 32.5% behind. But when you only do in-state comps, when the in-state comps are not considered, they're only 25% behind. Much more dramatically, licensed practical nurses, they also show up on both surveys. In-state comps, LPN 2s are 30% behind. But if you only use out-of-state comps, they're only 10 to 15% behind. Now, the union submits that it would be improper to use different methodologies for different classifications within the same bargaining unit. All it does is create further rifts and divisions because people's wage compensation structure is essentially being measured by different rulers. The union didn't dispute the 2014 total comp survey. That's now really the only evidence in the record. Given that there's no ruler or no way to measure the non-DOC specific classifications, absent consideration of in-state data, because that's all that's there, it's really important that you consider the data submitted by the union that includes in-state comps for the whole bargaining unit. And that's found in Tedesco's, the Tedesco law firm work at Union Exhibit 41. It's really the only way to compare apples to apples, which is an important part of an interest arbitration process. I want to talk very briefly about the top-to-top versus top-to-mid issue. The state has proposed that the arbitrator compare Step L, which is the top step of the DOC pay range, absent the Step N longevity step, with the mid-range of the comparable jurisdictions. We submit there is no arbitral authority for that kind of approach. Again, arbitrators should be comparing apples to apples. You heard Anil Korea's testimony on that issue. There is just no policy reason why a top-step Washington State Corrections officer should be compared to the mid-range of other states' counterparts. It's an area of disagreement that doesn't require a whole lot more explanation, so we're going to leave it to you to figure out what the right thing to do is here. Turning to wages only or total compensation, the third issue, also a very simple, straightforward issue. Under a total compensation approach, which more accurately reflects the realities of what employees actually earn for their work, the Washington DOC employees fall even further behind the comps. It's not just about wages. We shut our eyes to the total package and we shut our eyes to a much more accurate picture of what employees are really earning. And again, if you look at the work of the Tedesco law firm at Union Exhibit 41, you can see a fuller picture, which takes into account total comp. On the fourth issue, cost of living. The arbitrators already rejected the employer's cost of labor approach, and we believe that's appropriate. But the comparator wages do need to be adjusted by a cost of living factor, because otherwise it skews the data unrealistically in favor of the state's position. The employers offered a very weak cost of living comparator in Employer Exhibit 4-30. And it's weak because we had some chuckles at the hearing about comparing different cities, but it really just compares state capital cost of living instead of overall state data, which is found in Mr. Aitchison's testimony about Exhibits 59 through 61.
What was the employer exhibit, please?
I think it was 4-30. You may recall that we heard some, I'll hang on, just let me know.
The union exhibit?
Union exhibit was 59 through 61.
Okay.
Well, for example, 59 was that chart about the relative value of $100 in Washington. And you may remember that, so all these other states that we're looking at, $100 in Washington was worth $96.90. This was Bill Aitchison testified about this. And in all but Colorado, it's worth more than $100. In other words, the cost of living is higher in Washington than all the other states that we're looking at. How much higher? Union Exhibit 61 shows how you adjust the numbers properly. And so for each of those 5 states, there's an appropriate adjustment. Colorado is 1.6%. Oregon is 4.4%. Nevada is 5%. Arizona is 5.1%. And Utah is 6.4%. If you compare these to Employer Exhibit 4-30, you'll find that they're substantially more than what the state is proposing.